Umar Khalid and Sharjeel Imam stand on a qualitatively different footing from the remaining accused. In prosecutions alleging offences which implicate the sovereignty, integrity, or security of the state, delay does not operate as a trump card that automatically displaces statutory restraint. The complexity of the prosecution, the nature of evidence relied upon, and the stage of the proceedings do not justify their enlargement on bail at this juncture. Hence, the appeals arising out of SLP Criminal 14165 of 2025 and SLP Criminal number 14030 of 2025 stands rejected. It's a little bit lengthy, but few paragraphs will be reading, only few paragraphs.
Please.
These appeals arise out of common judgment and order passed by the High Court of Delhi in Criminal Appeal 184 of 22 in connected matters, by which the High Court affirmed the rejection of bail applications filed by the appellants. The appellants stand arraigned as accused in FIR 59 of 2020, registered by the Crime Branch Delhi, arising out of the incidents that occurred in several parts of the National Capital Territory of Delhi in February 2020. At the inception, the appellants were booked under Section 147, 148, 149, 120B of the Indian Penal Code. Upon completion of investigation, a charge sheet came to be filed, alleging offences under Section 120B, read with Section 109, 114, 124A, 147, 148, 149, 153A, 186, 201, 212, 295, 302, 307, 341, 353, 395, 420, 427, 435, 436, 452, 454, 468, 471, and 34 of the Indian Penal Code, as also under Section 13, 16, 17, and 18 of Unlawful Activities Prevention Act 1967, Section 25 and 27 of the Arms Act, and Section 3 and 4 of the Prevention of Damage to Public Property Act 1984. Before this court, certain submissions have been advanced, which are common to all appeals, particularly on the question of prolonged incarceration and the plea founded on Article 21 of the Constitution. At the same time, each appeal also raises which are specific to the appellant concerned and which in turn the role attributed, the prosecution material relied upon, and the finding recorded by the court below, by the courts below. The judgment therefore first notices the broad factual background of the case and the prosecution narrative as emerging from FIR 59 of 20 and charge sheets filed pursuant thereto. It then considers the plea of prolonged incarceration and the statutory framework governing the grant of bail under Section 43D5 of UAPA. The scope of Terrorist Act under Section 15 of the Act is also examined to the extent it bears upon the submissions advanced. Before proceeding further, it is necessary to notice the principal submissions urged on behalf of all the appellants at the threshold. The submission rests on the length of custody undergone and the plea that continued incarceration in the absence of early conclusion of trials. Offends the guarantee of personal liberty under Article 21 of the Constitution. It is this submission which court proposes to examine first. We may at the outset clarify the limited compass of the present discussion. This court is not engaged in any abstract comparison between the Constitution and a statute, nor in declaring that delay must invariably prevail over statutory restrictions, or that delay can never warrant constitutional relief. The question is more precise. In prosecutions under UAPA, when delay and prolonged incarcerations are invoked as grounds for bail, what is principled approach by which a constitutional court is to examine such a plea? Article 21 occupies a central place in the constitutional scheme. The right to life and personal liberty and the insistence that any deprivation must conform to procedure established by law are foundational guarantees. The right to a speedy trial has been recognized as an important facet of this guarantee. It follows that pre-trial incarceration cannot be by the mere passage of time, be permitted to assume the character of punishment. At the same time, Article 21 has never been understood as operating in isolation from law. The constitutional promise is not that liberty will be unregulated, but the deprivations of liberty will not be arbitrary, unconscionable, or unfair. The expression, quote and unquote, procedure established by law reflects that balance. The UAPA, as a special statute enacted to address offences alleged to affect the security of the state and stability of civic life, represents a legislative judgment as to the conditions under which bail may be granted at the pre-trial stage. Section 43D5 of UAPA embodies the exercise of that judgment. It therefore becomes necessary to state with clarity the governing approach in prosecutions alleging offences which implicate the sovereignty, integrity, or security of the state, delay does not operate as a trump card that automatically displaces statutory restraint. Rather, delay serves as a trigger for heightened judicial scrutiny. The outcome of such scrutiny must be determined by a proportional and contextual balancing of legally relevant considerations, including 1. The gravity and statutory character of the offense alleged, 2. The role attributed to the accused within the alleged design or conspiracy, 3. The strength of the prima facie case as it emerged at the limited threshold contemplated under the special statute, and 4. The extent to which continued incarceration viewed cumulatively in the facts of the case has become demonstrably disproportionate so as to offend the guarantee of personal liberty enshrined under Article 21. The discussion thus far has been confined to the constitutional plea founded on delay and prolonged incarceration. That inquiry, though not necessary, does not conclude the consideration of the present appeals. The question that now arises is the manner in which the prayer for bail is to be examined, where the prosecution is governed by a special statutory regime. The UAPA Act is a special statute enacted to address forms of criminal conduct which, by their very nature, transcend ordinary breaches of penal laws and implicate the sovereignty, integrity, and security of the state. Parliament, in framing the Act and in subsequently strengthening its provisions, has proceeded on the legislative understanding that such offences are rarely confined to isolated acts, but are more often the culmination of organized, sustained, and conspiratorial activity unfolding over time. The statutory scheme of the Act reflects this understanding. Chapter 4 and 6 do not confine criminal liability to the final execution of a terrorist act alone. They extend culpability to preparatory conduct, facilitation, abatement, and conspiracy, recognizing that the threat to be addressed by the statute often materializes long before any overt act of violence is committed. The law thus proceeds on a process-based conception of criminality rather than an event-based one. It is this legislative backdrop that Section 43D5 assumes significance. The provisions constitutes a conscious departure from the general principles governing the grant of bail. Under the Code of Criminal Procedure, Parliament has imposed a calibrated restrictions on the power of the courts to grant bail in respect of offences under Chapter 4 and 6, reflecting its assessment that the ordinary presumption in favour of the pre-trial liberty requires modification where the allegations pertain to activities threatening the foundations of the state. At the same time, 43D5 does not exclude judicial scrutiny, nor does it mandate denial of bail by default. The restrictions operates only upon the court being satisfied that there are reasonable grounds for believing that the accusation against the accused is prima facie true. The provision thus preserves the judicial function while carefully defining its contours at the pre-trial stage. The court is thus required to examine the role attributed to the individual accused as emerging from the prosecution material and to determine whether such attribution bears a prima facie nexus to the offences under Chapter 4 and 5. While undertaking this exercise, the court cannot proceed on any consideration except restricting the contours of inquiry confining to law, where Parliament has prescribed a distinct statutory threshold for the grant of bail and where the prosecution places prima facie material suggesting organized and deliberate activity affecting public order and security of the nation. The court cannot turn a Nelson's eye to such material merely because incarceration is prolonged or liberty is invoked in abstract. Equally, where continued detention is not shown to be necessary to serve a legitimate purpose recognized by law, the court must not hesitate to restore liberty subject to stringent conditions that safeguard the larger public interest. The nature of evidence relied upon and the stage of the proceedings do not justify their enlargement on bail at this juncture, as noticed in detail in the discussion made here in above. Hence, the appeals arising out of SLP Criminal 14165 of 2025 and SLP Criminal number 14030 of 2025 stands rejected.
On Monday, the Supreme Court of India delivered a crucial order in the 2020 Delhi riots larger conspiracy case. The court denied bail to Umar Khalid and Sharjeel Imam, both accused under the Unlawful Activities Prevention Act, but granted bail to 5 other accused: Gulfisha Fatima, Miran Haider, Shifa-ur-Rahman, Shadab Ahmed, and Mohammad Salim Khan. A bench of Justice Aravind Kumar and N.V. Anjaria made it clear that bail application must be examined individually, stating that Umar Khalid and Sharjeel Imam stand on a qualitatively different footing compared to the other accused. Importantly, the court emphasized that delay in trial can trigger judicial scrutiny even in UAPA cases. While UAPA is a special law with a stricter bail condition, the court clarified that bail is not automatically barred and denial is not the default rule. The bench underlined that Article 21, the right to personal liberty, requires the state to justify prolonged pre-trial incarceration. The case related to February 2020 Delhi riots, which erupted amidst protest over the Citizenship Amendment Act, resulting in 53 deaths and hundreds of injuries, according to Delhi police. This judgment highlights the balance between the national security laws and the constitutional liberty.